This just exploded. Todd Blanche is under heavy fire. A federal judge already ruled he conceded violating the law. The Epstein files turned against him hard. $1,000 a day in sanctions now hang over his head. Last warning issued. The arrest threat is intensifying by the hour. Blanche is the acting attorney general of the United States. He is Donald Trump's former personal defense lawyer. Now he controls the entire Department of Justice. And the court is coming straight at him with full force. Judge Emmett Sullivan put it in black and white on June 25th. Blanche effectively admitted the DOJ broke the Epstein Files Transparency Act. The deadline came and went on July 2nd. Documents stayed locked away. Foreign language materials stayed completely hidden. FBI interview notes stayed incomplete and partially withheld. This is not a slow-moving story. This is open warfare. Survivors versus Blanche. A federal courtroom versus the nation's top law officer. Confirmation hanging by a thread at the exact same moment the sanctions clock is ticking. The pressure just hit a new peak. One more refusal and the consequences get personal and permanent. The title is not hype. The last warning has been issued. The fire is real. The threat is real. The stakes could not be higher. Every day that passes without full compliance raises the temperature. Every filing from Katie Fang's team sharpens the edge. Every statement from survivors adds weight. This is the moment everything changed. This is the moment the system started pushing back. The situation accelerated without mercy and without warning. In late June, the hammer dropped hard and public. Judge Sullivan released a detailed 48-page opinion. He ordered Blanche to produce specific unredacted records or show cause by July 2nd. The list was precise and damning. Emails discussing a torture video. Names of potential co-conspirators that had been blacked out. Handwritten FBI notes from agents who interviewed a woman alleging Epstein introduced her to Trump when she was about 13 years old. Those notes formed the basis for formal FD 302 interview reports that still had gaps. July 2nd arrived. The Department of Justice did not fully comply. Instead came the explanations and the delays. Not practicable became the official line on the foreign language materials. Claims about victim privacy were repeated, even as survivors said their own information had already been exposed. Requests for more time and a 60-day stay so the Solicitor General could consider an appeal were filed. The court was not impressed. Katie Fang, the journalist and attorney who sued him directly, refused to back down. Her legal team filed for contempt with clear language. They asked the court to hit Blanche with $1,000 every single day until he obeys the order in full. Blanche's lawyers answered with sharp, defensive language. They called the request absurd. They called it hyperbolic. They called it outlandish. They begged the judge not to impose the fine. They asked for the right to appeal immediately. They asked for any adverse ruling to be paused while that appeal proceeds. The filing landed just days before his confirmation hearing. The timing was impossible to ignore. At the same time, a second front opened in New York with even broader implications. 101 lawyers and judges filed a formal ethics complaint. They want a professional responsibility investigation that could end in disbarment in the state where Blanche is licensed. The central charge is conflict of interest on a massive scale. Blanche once defended Trump in high-profile criminal cases. Trump appears in more than 5,300 Epstein-related files. And Blanche has been the official overseeing the release of those exact files while serving as acting attorney general. The complaint calls his handling burdened by conflicts and reflecting adversely on his fitness as an attorney. That is not a casual accusation. That is 101 legal professionals putting their names on a formal grievance. This is the core collision that defines everything. Trump's former defense attorney now sits at the absolute top of the Justice Department, the same department that holds the files naming his former client thousands of times. Survivors say the release process protected powerful names while exposing victim information in ways that put real people at risk. Nude photographs of survivors went public in the initial dumps. Email addresses went public. Details that could be used to trace families went public. Meanwhile, the names of high-profile men stayed carefully blacked out in many of the same productions. The contrast is brutal, and it is documented. Blanche spent 9 hours with Ghislaine Maxwell across 2 days in 2025. Shortly after that meeting, she was moved to a lower security prison camp that normally bars sex offenders under Bureau of Prisons policy. Survivors waited 374 days just to get a meeting of their own with the same official. When it finally happened, it was only because Republican Senator Thom Tillis issued a direct and public ultimatum. Tillis said he would not vote to confirm Blanche unless the meeting took place. Blanche had previously claimed on the record that he was prohibited from meeting the women directly. After the ultimatum, he reversed course within hours, and the meeting was scheduled. 7 survivors, plus family members of Virginia Giuffre, walked into Justice Department headquarters. They spent roughly 90 minutes in the room with Blanche. Multiple people who were there described the session as patronizing and dismissive. One survivor said Blanche disputed almost everything they raised. He told them to take their information to the FBI, the same agency they believe failed them for years and years. They left feeling the burden had been pushed right back onto them. They left more determined that Blanche should not be confirmed. The confirmation hearing itself became another open battlefield. On July 15th and 16th, Blanche sat in front of the Senate Judiciary Committee for 2 full days of questioning. Senators pressed him on loyalty to Trump. They pressed him on the files and the missing pages. They pressed him on the nearly $2 billion IRS settlement fund that critics call a political vehicle for allies. Blanche insisted he is not a yes man. He said counsel does not mean automatic agreement with the president. He claimed the Trump administration has been more transparent on Epstein than any previous administration. He apologized for redaction mistakes that exposed victims and said any mistakes should not have been made. He vowed that no investigation is closed. If credible new evidence appears tomorrow or next month, the department will investigate and prosecute. But the court order still stands unfulfilled. The contempt motion is still live and active. The ethics complaint is still pending in New York. And several key Republican senators have not locked in their votes even after the hearings. The fight is personal, the fight is political, the fight is legal, and none of it is slowing down. Every new filing keeps the temperature high. Every survivor statement adds another layer of pressure. This is the main event, and it is still unfolding in real time. The strongest evidence cuts the deepest, and it is all on the public record. Judge Sullivan's own language is unambiguous and repeated. The acting attorney general has conceded he is in violation of the act. Congress passed the Epstein Files Transparency Act in a bipartisan vote. President Trump signed it into law in November 2025. It required the public release of the vast majority of Epstein records held by the government. The department released roughly 3 million pages under Blanche's oversight. That is about half of what the government holds, according to multiple reports. Millions more remain unreleased and unaccounted for in the public production. The specific materials ordered by the court include handwritten FBI interview notes that formed the basis for formal reports. Those notes involve the woman who alleged she was 13 when Epstein introduced her to Trump and that an assault followed. The FBI found her credible enough to interview her multiple times. Yet key pages and underlying notes stayed incomplete or withheld even after the court order. Emails with sender and recipient names still redacted include exchanges discussing a torture video and sexual activity with young women, some of them minors. Documents that name potential co-conspirators were ordered produced with names unredacted or explained. And an entire category of foreign language materials has never even been reviewed for release under the Act. Katie Fang has publicly stated those foreign language documents could contain huge keys to new charges, including possible action against Maxwell in other countries where she holds citizenship. The department's formal response was that reviewing them is not practicable and that the court should not override Congress's acceptance of that explanation. The judge was not moved by that line. The ethics complaint from the 101 legal professionals lays out a broader and more systemic pattern. Failure to recuse from matters involving a former personal client, handling of the Epstein files that critics describe as prioritizing political protection over legal duty and victim rights, preferential treatment allegations surrounding Maxwell's prison transfer after the long interview, and the creation of a nearly $2 billion settlement fund that opponents call a political slush fund for Trump allies. These are not internet rumors or partisan talking points. They are findings from a sitting federal judge. They are a formal grievance filed by over 100 lawyers and judges. They are on-record statements from survivors who appeared before the Senate and in closed meetings. Every one of these points lands with force because the paper trail is public and growing. Every one of these points keeps the tension high because the compliance clock is still running and the confirmation clock is still running at the same time. The evidence is selective, but it is the strongest available, and it is damaging on its face. The human cost is not theoretical, and it cannot be reduced to process arguments. Survivors have spoken with raw clarity and consistent detail. They say their private information was exposed in the releases while the names of powerful men stayed protected. They say the department declared the major investigative work finished, even while leads and documents remained. They say the man nominated to lead the entire Justice Department spent 9 hours with the convicted trafficker and gave the people she helped traffic 90 minutes after a 374-day delay forced by a senator's ultimatum. One survivor testified that Blanche refused her repeated requests for a meeting for nearly 9 months while the confirmation process advanced. Another described the eventual session as a mere check-the-box exercise designed to secure confirmation votes rather than to listen. Family members of Virginia Giuffre sat in that room. They left believing they had been sent back to square one and told to start over with the FBI. The emotional weight is heavy because the stakes are personal and long-running. These are people who lived through the crimes and the aftermath. They watched the files get mishandled in public view. They watched the top law officer of the country prioritize other meetings and other priorities. They watched redactions that left them exposed while shielding others. That is the human angle that cannot be ignored or minimized. That is the cost that keeps the energy high and the pressure continuous. Their voices are the reason the conflict refuses to die down. Blanche and his defenders present a different and consistent picture. They argue the volume of material was massive, millions of pages that required a Herculean review effort by the department. They say many withheld records were duplicates from different investigations covered by legal privilege or related to entirely different people who share the Epstein name. They insist victim privacy forced careful redactions and that any mistakes were fixed by immediately pulling documents offline once the errors were discovered. Blanche has repeated in public and under oath that the investigation remains open. Any credible new evidence will be investigated and, if warranted, prosecuted without hesitation. He told senators the White House has nothing to hide in these files and that President Trump has been asking for transparency since before the election. President Trump has publicly praised him as a great lawyer who is always fair and has urged every Republican senator to confirm him as quickly as possible. Some Republican senators have expressed private concerns about the IRS settlement, the anti-weaponization fund, and other issues, but have not publicly walked away from the nomination. White House officials continue working the votes and providing assurances. That is the strongest version of the defense currently on the public record. It does not erase the court findings. It does not erase the survivor statements. It does not erase the ethics complaint. But it is the counter-argument that must be stated fairly and briefly so the full picture is visible. The energy does not drop because the counter-arguments themselves are under pressure from the same court orders and the same survivor accounts. Why this fight matters reaches far beyond one man's confirmation or one set of documents. The Attorney General is the highest law enforcement official in the country. When that official is simultaneously the subject of a federal court order finding a conceded statutory violation, an ethics complaint seeking disbarment, and open public conflict with Epstein survivors, the credibility of the entire Justice Department is on the line in real time. Transparency statutes only function if they bind the people who hold power. Conflicts of interest only matter if they are treated as serious enough to disqualify someone from the highest offices. The trust of survivors only survives if the people controlling the evidence treat those survivors as more than a political inconvenience to be managed for a hearing or a vote. This battle is a test of whether the Epstein Files Transparency Act has real force, or is simply another law that senior officials can slow walk when it becomes politically inconvenient. It is a test of whether a former personal lawyer to the president can fairly supervise the release of files that name that same president more than 5,000 times without the appearance of bias. And it is a test of whether the United States Senate will confirm him while a federal judge is still deciding whether to impose daily financial sanctions for ongoing noncompliance with a court order. The answer to those questions will shape more than one nomination. It will shape whether the system still has teeth when the subject of the order sits at the top of the department. It will shape whether survivors believe the process can ever deliver accountability. That is why the energy stays high. That is why every development matters to people watching from outside the Beltway. Right now, the status remains tense, unresolved, and moving on multiple tracks at once. The confirmation hearings are finished. Written follow-up answers running hundreds of pages have been submitted to the committee. A committee vote and possible full Senate vote are the next procedural steps. Some pivotal Republican senators are still in active discussions with the White House about remaining concerns. Cornyn and Tillis have been named in reporting as key voices whose support is still being worked. In the courtroom, Blanche has formally asked Judge Sullivan to reject the sanctions request in full. He has asked for the right to an immediate appeal. He has asked for any adverse order to be paused while that appeal proceeds. Katie Fang's legal team continues to demand full compliance with the June 25th order and the daily fine until compliance is complete. The New York ethics complaint remains pending before the Attorney Grievance Committee with no public resolution yet. Foreign language materials still have not been reviewed and released as ordered. Specific FBI notes and unredacted emails ordered by the court still have not appeared in the public production. What happens in the coming days and weeks will be highly visible and highly consequential. A ruling on the contempt motion could come at any time. A committee vote on the nomination could lock in or block the path to the floor. Possible floor action in the full Senate before the August recess remains on the table, according to leadership comments. Further document production or continued refusal and further appeals will determine the next phase of the court fight. Every one of those moments will signal whether institutional limits still exist when the person under the order holds the highest law enforcement title. The next move could come at any hour. That is why the pressure has not eased for a single day. That is why the last warning language fits the moment. This is the last warning phase, and it is still active. The fire is already intense, and the sources of that fire are multiplying. The language of arrest threat in the headlines reflects the escalating risk of civil contempt. Civil contempt often begins with daily fines of the kind already requested. It can escalate further if the court concludes the defiance is willful, ongoing, and in the face of clear orders. Criminal contempt remains a separate and more serious possibility in related contexts, according to some legal analysts, though the current public focus is the civil sanctions track. The Epstein files are not closed business. The survivors are not finished demanding answers or opposing the confirmation. And Todd Blanche has not yet been confirmed as Attorney General. The combination of those three facts keeps the entire situation on a knife edge. Every new court filing, every new survivor statement, every new senator comment adds fuel. The tension that started in the cold open has not broken.
It has only tightened.